we'll be taking presentations quickly. We'll be taking presentations quickly from you guys, right? So we would want to have presentation from you. So the presenter for this week, you can go ahead. I'll stop sharing my screen now. You can go ahead, start your presentation, and let's just get down straight into the business of today. Once again, welcome to class.
Okay, good evening, sir, and good evening, everyone. Please confirm if you can hear me.
Yes, we can.
Yes, good evening, Christian. We can hear you.
Okay. Okay, sir, I don't know if it's possible for you to share the presentation. I don't think I can be able to do it from my end.
Okay. Sorry, just give me a moment, 1 minute to do that. Let me bring it up.
Okay, thank you.
Sorry. Sorry, it's coming up very soon. Sorry for the little delay. All right, can you see my screen?
Yes, we can.
All right, Mr.
Okay, yes,
Christian,
I
you can.
can. Okay, thank you. Once again, good evening, everybody. My name is Christian, and in this presentation, I'll be the group presenter, or I'm the group presenter. So today, I'll be talking on the topic optimizing application strategies, a comprehensive analysis of filing processes, duration, and priority considerations in provisional, local, regional, and international context. So for the purpose of this presentation, we'll be making use of the subtopics that have already been communicated to us and also the group presentation. So by way of introduction, the topic is centered on exploring the concept of provisional patent application or patent application, and also exploring the different routes for filing a patent application. For example, the national or local route, the regional route, the international route, and we are also going to be looking at priority dates. So from here, we have patents protect inventions from imitation, like we have been learning from the onset of the class. That's the essence of patents, is to give the patentee an exclusive right to reproduce or sell his invention, and that right excludes others from imitating that particular invention. Also, there are different filing strategies. We've also learned what the concept of filing strategies, and there are different filing strategies. So for this purpose, we are going to be looking at the provisional filing strategy, and then also the sources of patent depends on timing, scope, and cost. So like we have already been told, in terms of IP rights, time is of the essence. And so it is very important that you file, if you have an invention, you protect that invention timelessly. So let's move to the next slide. So for the provisional patent filing or patent application, so the concept of provisional patent application has to do with an avenue where a person is allowed, an inventor rather, is allowed to file an application to protect his patent. However, he is given a period of usually 12 months to file the non-provisional patent application. such that if the person has not yet, let's say he has not completed, he needs to do some modifications in the invention, or he's not yet ready to file the normal patent application, he may want to file a provisional patent application to secure a priority date, so that when he's filing the non-provisional patent application, he can be able to claim the priority date. So if, for example, he has filed a provisional patent application today, and then the main patent application is filed by December, he can be able to claim that his invention was protected today. So that's the whole essence of provisional. It is allowed in some jurisdictions. However, in others, it is not provided for under their laws. For example, I think Nigeria does not allow for provisional patent application. However, I stand to be corrected. So from the slide, it says a temporary application filed to secure an early filing date, like I said, and also it lasts for 12 months before a full application must follow. So some countries that practice this provisional patent filing, like the US and also China, also practice this system. So how does it work? How does provisional patent application work? The first is that the filing process, how does the filing process operate? So the first thing you need to do if you want to get a provisional patent application or provisional patent, the first thing you need to do is to prepare a detailed description of the invention, and usually the description contains your title, the title of the invention, the name of the inventor, and the address of the inventor, and also if you're making use of an attorney, a patent attorney, you can also include relevant information about the patent attorney. Then also you need to draft a specification, which necessarily includes drawings. Now for this, a specification is more like the main content about the invention, and this includes the background of the invention, also a summary of the invention. For the purpose of the background, you can highlight, in the background of the invention, you can highlight some problems that existed with prior act, and also state that this is what your invention wants to remedy. Let's say, for example, using an example of a chair that has 2 legs, for example, 2 legs, and then you want to invent something that, or you have invented a chair that has 4 legs, you can state the problem of the prior art, and then that problem is what your own invention wants to remedy. So you can include that in the background of the invention. Then also, you need to have a summary of the invention, stating the specific purpose of the invention, the reason why you are putting forward this particular invention. Then also you attach some drawings. The drawings is more like a description, a diagrammatical description of your invention. So you also have to include that. Then also a detailed description of the invention. Now this is quite different from the background of the invention. Now for the purpose of the background, you are just stating the problems that your invention wants to remedy. Whereas for the detailed description of your invention, you are stating how your invention functions, and then how it is trying to remedy that particular problem that has existed because of the prior art. Then also, in filing a provisional patent, you also have to pay the prescribed filing fees, and this of course varies according to jurisdictions. Then, having done that, you have to submit your application to the relevant patent office. For the US, we have the USPTO. Now, also, you can also file online. Yeah, in some jurisdictions, they allow online filing. So you can also file online. And having said that, there are some advantages of provisional patent filing. Some advantages, or rather you can call it benefits. Now for this purpose, some of the advantages have already been highlighted here, so I'll just be speaking to it. So the first is priority date secured. It protects your idea against later filings. So like I've already said, in IP protection of IP rights, time is of the essence. Yeah, time is of the essence. And so you want to secure an earlier time so that when you are filing later, maybe after you've done some modifications and you want to file subsequent, you can be able to make use of the prior date. So your invention will be taken as to having filed the prior date, the date you filed the provisional patent. So it helps you to save that time. That's the priority date, properly so called. Then also, patent pending status. It allows for safe marketing of your invention. So let's say, using a practical example, let's say you want to get an investor. Let's say you don't have the necessary finance to fund your invention and you want to get an investor, but you're not yet done with the invention. You still have some modifications to make. And maybe you are scared that, oh, if you get an investor, he or she may not be willing to non-disclosure. So for that reason, you protect your invention just in case since you're revealing details about your invention, the investor, so the investor cannot take advantage of your invention and then leave you behind. So that way, if you file a provisional patent application, it allows you to protect that invention. And so even if you disclose or reveal some essential features of the invention to the investor, you are not you are making a safe market. You're not scared that, oh, he might take advantage of this and then leave you behind. So that's for that. Then also 12 months buffer time for refinement, funding, and testing. So like I said, if you have an invention and you are not yet done with the invention, maybe you have arrived at a substantive aspect of it, but you still need to make few modifications, then you can decide to file a provisional patent application. So while that is pending for a period of 12 months, you're modifying, you're working on it, you're refining your invention so that before the expiration of the 12 months, you can file the non-provisional patent application. Then also it lowers costs. Basically, it is cost effective, unlike the non-provisional patent application. And also it is quick, unlike the non-provisional patent application. And the reason why it is quick is that no much examination is done over the invention. Unlike when you file a non-provisional patent application where a substantive examination is done to ensure that your invention is different from that of prior art. But when it comes to a provisional patent application, no much examination is done. Rather, the examination is saved till the date or the day you file the non-provisional patent application. So that's everything about provisional patent application. So let's move to the next slide. So the next slide is local patent filing. Now, this is same as national patent filing. You may want to file in your country. Maybe you have an invention, you want to protect that invention in your country. So this is where this area comes in. And for this purpose, we'll just be looking at Nigeria because the majority of us are in Nigeria. So in Nigeria, you can file through the Trademark, Patent and Design Registry. This registry is under the Federal Ministry of Industry, Trade and Investment, one of the ministries in the federal ministries in Nigeria. So there is a department that houses the trademark, the patent registry. Now in this department, it has a registrar, and you can file your application through that means. You can file your application in that office, in that registry. Now also the steps include assessing the invention, searching for novelty, preparing the application, filing and paying fees. Now the patent application in Nigeria is regulated by the Patent and Design Act, which has also been codified in the laws of the Federal Republic of Nigeria, laws of the Federation of Nigeria, LFN 2004. Now it has provisions relating to the requirements for filing patents. Now some of the requirements are the name of the inventor, a description, detailed description of the invention, and also the address of the inventor, and show that one again. I think okay. You also have to include the claim, your claims. So, and also if necessary, you may also include drawings to describe, or more like put your invention in a diagram. So these are like the requirements for patent application. Now, when you file in the registry, a formal examination is done. Now, the formal examination is more like checking if you've included the necessary documents, you follow the necessary procedures. It's not really checking whether your invention is different from prior art. So it's not doing substantive examination. So what is being done is formal examination. When you have been granted patent and it has been published, and let's say there is a prior act that is similar to your invention, then there can be, of course, there will be disputes as to contesting, oh, this invention is more recent, this invention is novel, and all of that. So when that particular dispute arises, you approach the court, and it is at that point you can now do the substantive examination in order to resolve the dispute. So also, filing fees is also required in Nigeria, and then your invention must fall under the category of patentable inventions in Nigeria, provided under the Nigerian law to the Patent and Design Act. It must be new, it must be inventive, and then it must have industrial application. We've done all of that. So the duration for local patent filing in Nigeria is usually 6 months. Okay, the duration for grants rather of patents. So if you file, you can take maximum of 6 months before you're granted your patent. Then also, like I've already said, Nigeria does not conduct a deep substantive examination, but rather a formal examination. Then some of the key points you need to know in Nigeria is that the rights apply within Nigeria. So a grant of patent applies within Nigeria. Then also, you need to take note that the period of your exclusive right is for 20 years. Yes, for 20 years. After that, the invention moves to the public domain. Then some of the key points to note also, okay, I've done that. I've done the key points. So this is basically what the Nigerian patent application looks like. How you file, what documents are required, and then how patent is being granted in Nigeria. So this is basically how it looks like. Next slide, please. So before we enter the regional patent filing, it is also important to note that there has been some innovations in Nigeria. There has been some innovations such as the online filing through the IPO, the IPONigeria.com. You don't necessarily need to go to the registry in Abuja. You can file online. So that way it's even more easy because most of us can access the internet from any part of Nigeria. So that way is more easier for you and even cost effective. While the nuance or the gap in patent application or patent filing in Nigeria is the issue of examination, the issue of substantive and formal examination. Nigeria, like I said, carry out formal examination. We don't do substantive. So you may not really know whether or not your invention rather, is similar to that of prior art, except maybe when there's a dispute, you can now go into the substantive aspect of checking whether your invention is new, novel, and the rest, or whether it's similar to prior art. Then also, Nigeria doesn't have a database to check previous inventions. So we don't have a database. And so that's also an issue with patent application in Nigeria. So let's move over to the regional patent filing, and we have to be fast for the time. So for this has to do with filing regionally, filing based on regions. So we have different regional bodies. We have the EPU, we have the JIIPCC, and then we have the OAPI. We have already outlined the members of these different regional bodies. Now, how does it work? When you file in a regional body, you can be able to designate member states. So let's say, for example, you file in the EPU, and let's say there's a particular country who is a member state of EPU. You can be able to designate that particular invention to that particular country, such that you may not necessarily need to go to that country to file. So that way, it allows you easy access to file in that country regionally. But of course, your invention must meet the requirements from that country. Then also, some of the benefits of regional patent filing includes one application for the protection of multiple countries. Like I said, you can just file in the regional body, and then it will apply to and designate to other countries. Then also, it saves time, reduces duplication and cost. Then it encourages harmonized legal standards across the region. So when there's a regional body, there's like a harmonized legal standard, a harmonized procedure or requirement for patent filing. Then some of the challenges is that it doesn't cover non-member states. So, for example, the UK is not part of the EPU. So, if you file in the EPU regional body, you cannot cover for the UK because the UK is not a member state. So this is like a challenge. Then also, enforcement remains at the national level. What this means is that if there is a dispute and you want to challenge the dispute in court, you have to make use of the courts in the different national level. Let's say if the dispute arose in, let's say Nigeria, for example, you have to go to Nigerian courts, let's say the Federal High Court, to resolve that dispute. So these are the challenges. Next slide. Then for the international patent filing, for this one, it has to do with filing, like we have already been told, there's nothing like global patent protection. What we do is international. So you can decide to file internationally. And for this purpose, we have the Paris Convention, and then we have the PCT, Patent Cooperation Treaty. Now, also note that everything we have been saying is under the question where, like we've already been told, patent strategy has several questions like where, when, and the rest. So all these are under the question of where. Where do you want to file your application? So for the international patent filing, you can decide to make use of the PCT. The PCT is like a treaty. How it operates is that a country who is a signatory rather to the treaty if you file in that country, you can be able to file in another country who is also a signatory to that treaty. Let me give you a practical example. For example, Nigeria is a part of the PCT. It recognizes foreign priority. What it means is that if you file in a country that is under the PCT, now you can also file, and you decide to file in Nigeria, you can claim the priority date of when you filed, or when you file your application, when you have already filed your application in that other country who's a member. I believe I'm communicating for. It just works in a way that you can be able to claim a priority date of when you filed in a different country, insofar as that country is a member or a signatory to the treaty. Then also, some of the strategies under this international patent filing is that it helps you to file or to designate in a market-driven country. Let's say you want to file your application in a country that has the available market, or you want to file in a country that has competitors and the likes. So it helps you to file in that particular country. You may not necessarily need to go to that country to file. You can just file, insofar as the country is a signatory to PCT, you can just file internationally and then designate to that country. Or you can make use of, if the country is not a member of PCT, then you can go through the national filing. However, it's the country, your invention must meet the requirements of the country. Otherwise, your invention may not be granted patent protection. The next slide, please. So the duration of patent application in Nigeria, like I said, is 6 months. And the reason is that we do only formal examination. So it doesn't take much time. Then for other countries like the US, 2 to 5 years, the US and European countries, 2 to 5 years, and then Canada, up to 4 years. And the reason is that they carry out substantive examination. So that can take a lot of time. So the factors that affect the duration is that, the factors that affect the duration include office backlog, and then examiner workload, filing, and prosecution choices. So the workload in some of these offices affect the duration of filing. And then it's also important to note that the duration of patent itself, a grant of patent, is usually 20 years, depending on jurisdiction. In Nigeria, it's 20 years. Then, that's for the duration. And the reasons, like I've already said, office backlog, the duration of the time required for examination. So countries that carry out substantive examination, they take much time than those that carry out formal examination like Nigeria. Next slide, please. Then priority dates and periods. When we started with provisional filing, we talked about priority date. Priority date is simply the date in which you make the initial application. So you can claim that date when you make a subsequent application. Priority date can also apply where you file in a country and then you want to file in another country that is a signatory to a particular treaty like the PCT. If you want to file in that particular country, you can claim a priority date. That's the date you filed in the other country. So priority dates allows you to claim the dates of the first patent filing for an invention. Then also establishes the starting line for who owns the invention. Then the legal basis, priority date is recognized in different laws, like the Paris Convention. It's also recognized in Patent and Design Act in Nigeria. I think about section 27 or thereabout recognizes priority date. And the applicant has 12 months to claim the same priority when filing in other countries. So what it means is that if you file in a country and then you want to file in another country, you must do so within 12 months before you can claim that priority date over that particular invention. So let's say, practical example, you are filed in Nigeria, and then let's say you're filed in Ghana. Ghana is a signatory to ECT, and then you also file in Nigeria, who is also a signatory. Now, you must do so within 12 months, and then you can claim the priority date in which you filed in Nigeria. So that's for priority date. Then the significance is that it secures the earliest rights even abroad. So like we have already said, in protection of IP rights, time is of the essence. Then also it blocks competitors from claiming the same invention. Yes, so competitors are precluded from claiming that particular invention insofar as you have been able to claim a priority date and you have followed the procedure for claiming a priority date. Then also it expands protection internationally. Like I said, if a country in Nigeria, if a country is a signatory or a member of PCT, haven't filed in that country, you can also file in Nigeria and claim the date in which you filed in the other country. So it expands protection internationally. Then note that missing the priority period can cause loss of rights in foreign markets. What it means is that if you don't file within 12 months after the date you filed, like after the date you filed in another country, if you don't file within 12 months, then you can you may not be able to claim that priority date because it's outside the period of claim, usually 12 months. Next slide, please. Okay, in conclusion, optimizing patent filing strategies means choosing when to file, where to file, and how to manage costs. Start provisional to secure priority, then file local for immediate jurisdictional rights, then expand regional or internationally where markets and competitors demand. A balanced approach ensures strong and civil rights that aligns with business goals. So filing an application, a provisional application can help you see an early spot. Then also you can also decide to file in your country, you can decide to file regionally, you can decide to explore the international route. So all these are under the question of where to file. Then also it helps to expand regional or internationally. Okay, it helps you to expand your protection regionally or internationally. And then you can be able to compete favorably in the market. So this is the end of the presentation. Okay, let's move to the next slide to be sure. Okay, this is the end of the presentation, and these are the members. Thank you for listening. Thank you.
All right. Thank you very much, Christian, for your very wonderful presentation. Well done to you and to your team for putting it together. We really do appreciate the efforts and the time it took to do that. So yes, we have Mrs. Amosa Shukurat with us. All right. So thank you, ma'am, for joining. In today's class, we are discussing filing patent application. We want to hear you share your thoughts on the topic, give feedback to the mentees, and also considering that this will be the last session for the patents class, maybe any advice you want to give to the mentees, as they continue in their search or, with the enthusiasm of coming into this patent space. So over to you, Mrs. Shukurat.
Hi, Dennis. Can you confirm you can hear me?
Yes, ma'am, we can hear you.
All right. Good afternoon, everyone, and welcome once again to another session on the JIIPCC Mentorship and Internship Program, focusing on patent drafting, yeah, basically. Thank you to the presenter. You've done a wonderful job, but I think there were some places you were giving some terms, like kind of mixing it up. So I think I'll start with your slide 2. where you mentioned strategies for patent application. So when you say strategy is different from route, okay? Strategies is what way can I what can I put together, or what ways can I use to actually u- put together before I file. So the routes you take in filing is it's more like a strategy, but you can't really classify it under strategy because you classified provisional application, and also international, regional, and local as strategies. But basically, it's good to distinguish between the route of filing, even though the route can also be a form of strategy that you take when filing. So when you are talking of strategies, maybe you want to look at provisional and non-provisional. And in some cases, countries that provide for utility filing finish could also be a strategy. Then when it comes to the route you want to take to file, then you focus on national, regional, and international. Also, um, you did well to explain some aspects. But another thing is when it comes to the PCT route, I think you didn't really explain much on how it happens. So most times you need to have a deep understanding, because what we have here is probably a very thorough understanding, and you might not be able to answer some questions with the understanding you have presently. But because of this is the last session, I'll employ you to take further courses, because I know that most times, most of these assignments are just you go online and you put things together. It doesn't really mean you understand the deep aspect of it. And I think it's Muna shared something on the PCT webinar. There is a WIPO PCT webinar coming up soon. So I think you guys can also register for that webinar. So you have more understanding of how it works. The WIPO Academy portal is also opened for you to take some of these courses. It's just that to be able to take the advanced courses, you courses with the USPTO. I think some of them are paid, but some are also free. So depending on your understanding, you want to take some other courses to be able to understand these things, because most times the um the theoretical aspect, right, is different from the what's it called? It's different from the application. And just like you've read that provisional application applies in some countries, it doesn't apply in some other countries. Like you mentioned, Nigeria does not go through that aspect of provisional application, but it's applicable in some other countries. And just like the Paris Convention provides for provisional application and grace period, it's not all countries that adopt it into their patent system. So like I said, I implore you to, if you are really interested in patent, because there are so many opportunities when it comes to patent. It's just that the Nigerian economy has not keyed into innovation yet. And as lawyers, you need to understand the intrinsic aspects of patent, so that when that time comes, you'll be able to stand out as a patent, should I say patent attorney. And also, you don't want to limit yourself to just Nigeria, because we really do not have a certification process for patent attorney or even IPA consultant or expert in Nigeria. So that's why it's important for you to spread your tentacles and look at other international organizations that do patent or trademark, depending on which one you are interested in. So I think we'll open the floor for question and answers at this point, so I don't take too much time.
All right. Thank you so much, Mrs. Shukurat, for giving feedback to the presentation. So please, if you have questions that I would like to ask, let's do well to ask questions, right? Feel free to raise your hands, indicate by raise of hand, or you can send your questions into the chat box and I'll read them out. So if you have a question, please.
Okay, I think someone has a question. Someone was asking if amendments can be made to a patent application after filing. Yes, if the amendment is not something that is going to make the application very different, amendment can be made. So the amendment has to be something that is very not very substantial, okay? Such that it's not going to change the application all over. So in I think in the US, when you file your application, there's something called I'm trying to remember, but I can't remember. It's more like they'll let you know how the process is going. They'll keep you updated of how the process is going. If you need to add, maybe you need to submit translation. Okay, let's assume you are from an English speaking country and you are filing a country like, let's say, China, that will require translation. If you don't attach translation to your application, they're likely going to get back to you to send in translation. And maybe your drawings are not well done, it's something that you can still do. But if the changes you're going to make is going to affect the application as a whole, then you might not be able to make that change. I hope that answers your question. And also in the Nigerian Patent Office, if your application is not coherent and you need to like add one or two things, the registry is going to notify you and you can do that as well. I hope that answers your question. Okay.
All right. Thank you very much, Ma, for helping us answer that question. So please, do we have any more questions we'd like to ask? Okay. I guess we don't have any more questions we would like to ask. So I just want to kindly ask Ma if, well, like considering that this is the last class we'll be taking for the patents drafting class, I don't know if there is anything you want to point our mentees to that maybe you may have missed out during the course of the program, or any advice you want to give them going forward.
Basically, everything starts with interest. So at this point, it seems everybody has showed interest in the patent course because majority of all the people I can see here, I've been seeing them consecutively in classes. So that means you're actually interested in patents and you also have been doing your assignment. So all you just need to do is, this shouldn't be the end of it for you. You should ask yourself, what do you want out of it? Why exactly are you doing this? Do you just want to have an idea of what patent is about, or you want to be someone that is going to make an impact in this field? So from what you've done so far, you might not have the opportunity to be able to, because patent is not an area whereby you see people really dive into. And it's just few of us, I would say, that are really doing patent. And even the few of us that are doing it don't really talk much about it because it's not a field where people are really interested in. And that's because we don't have so much innovation going around, or let's say we don't have access to those who actually need it. So we need to continue spreading information about it. Whatever it is you've learned during the course of this internship, make sure you put it out there. Read up. The only way you are able to improve yourself is putting things out, because when you learn something and you don't work with it, you tend to forget, right? So Any opportunity you see that is on patent, apply for it. Download materials. WIPO has so many materials on patent. Download them. Try as much. Another thing I've noticed young people do is they are interested in something, but they don't want to work for it, right? You are just starting, so you shouldn't place yourself as an expert when in fact you really don't know much about it. If what is going to take is for you to bring down yourself a bit and work with someone who already has the knowledge, then you should do that so that you're able to acquire the knowledge that you need to be able to move forward. Okay. So I think this would be my advice for everybody. Try as much as possible to volunteer without payment. And if you are doing that, put in your all, except when you see that you are not getting results for what exactly it is you are doing. Try to pick up materials, read up on it, work with people, let them show you the processes. Because I noticed the presenter was saying something about IPO, that's the International Patent or Intellectual Patent Office. But if you notice, most of the information on IPO doesn't correlate with the information that you are supposed to have. So sometimes you might be working with outdated knowledge, thinking that that's what it is. But there have been so many platforms created for intellectual property, such that when there is no regular information, they kind of leave that one and open a different one. So you have to be updated. You have to know what's happening. So most of those information you find online might not really apply when you're looking at application filing itself. How do you go about it? Because the online system really, it's not very comprehensive. You still have to go through the manual filing. So even if you say that you are an IP agent and you are filing through the manual system, through the online system, you still need to go back door to file manually if you want people to work on your application. So it's not a one-way street. You have to know how it works. And even when we started, I know they chop my money very well, but these are the things that you have to do to be able to get to the stage that you want to get to. So yes, final words, passion, interest, what is your why? Where are you going to? Why are you doing it? Your drive. You should just keep going. Yes, that will be all for now. Thank you so much, Dennis.
All right, thank you so much, Mrs. Shukurat, for um just those final words. Yeah, so I think it's safe to say, all right, class has been quite interesting, and we have had so much impact in terms of the overall knowledge that has been shared during the course of over the course of the last 5 weeks, right? And we hope that the things you have learned are things that are applicable and things that you would take and build upon that enthusiasm to make yourself a better patent drafting specialist, right? Well, this is the end of the patent class, but it's not overall the end of the program. We still have a few other classes to go, but those classes are going to be done in collaboration with the other sub groups or these other sub courses. So yeah, so just before we go in today's class, like it's our practice, I think let's say we're taking our last official picture. It's almost raining in my location, so my place is very dark, but I'll still keep my camera on my second device. So please, let's quickly do how to turn on our videos. Let's quickly take a screenshot, a quick picture, and then we'll call it a day for this session. Right, so please let's quickly do that, and then we can just head out. All right, thank you, Eugenia. Okay, thank you, Ugochi. Thank you, Mr. Kristen. Thank you, Temitope. Thank you, Chidima. I'll just give us a minute for us to settle in so that we can properly turn on our videos, and yeah, we'll take our picture after that. So All right, so we're done with that. Once again, a big thank you to everyone. All right. See you all in the subsequent classes. Thank you so much, Mrs. Shukurat, for helping us run through the last 5 weeks. We really, really do appreciate everything that you have done for us, and your constant presence. We are very, very grateful. Please, for the mentees, like we always encourage you, do not forget to share what you have learned in each session. I think it's one of the ways you get to tell people that, okay, this is a field that you are getting involved in, right? And that you are expressing some form of knowledge, or some form of interest and enthusiasm in, right? So please do well to share what you have learned. Do well to tag our mentors, right? Ms. Chukurat, she's someone who is very vast in this space. So let's do that. Let's do that. Right. So yeah, with that, we come to the end of today's class. See you all for the mentees. See you all next week. The tasks and the schedulings for the other classes will be sent to your group. Thank you, everyone, and bye-bye.
Thank you so much, Dennis. Bye, everyone. See you at the top.